Hello, this is Phillip Taylor from Richmond Green Chambers and from the Mallet Street Gazette Barrister Desk, which I edit. I'm talking about a very interesting case called Rondel versus Worsley, or Rondel versus Worsley, which was reported in 1967. It's a House of Lords decision. The reason I've included it is because it's one of the very first cases I ever read when I was a law student back in 1970. And the case, in fact, at that time was a leading authority about what barristers could do. I've got the law report in front of me here, and I'm going to read a few extracts from it, which I think you'll find very interesting. The issue is about the liability at that time of a barrister for negligence during court proceedings. What the facts were, Mr. Rondel wasn't a very nice person, I hasten to add. The facts were these, that in May 1959, he, Norbert Rondel, was tried on charges of causing bodily harm to one M with intent. He pleaded to the acts, which he didn't deny, that they were justified, so his defence was justifiable. The defence was undertaken by what was then known as a doc brief, and the doc brief was actually given to Worsley, who then went on at a much later date to become much more well known. But Mr. Worsley, because it was a doc brief, wasn't instructed by a solicitor. He just went down to the cells, saw Norbert Rondel, took some instructions, and then tried to represent him in court. As a result of this, obviously Mr. Worsley, Michael Worsley, was a barrister at law. What happened, though, of course, is that Rondel, who was a debt collector and had bitten off someone's ear, just so you've got some idea of what happened, he actually was convicted and sentenced to imprisonment. And his application for various leaves to appeal, including complaints against Michael Worsley, were refused. Now, that's in 1959. We then move on to February 1965, when Rondel issued a writ claiming damages for professional negligence against Worsley, following a statement of claim drawn up by Mr. Rondel, which actually was defective. The problem is there were a lot of subsidiary issues which were discussed, and this case, of course, went from the Queen's Bench Division to the Court of Appeal and then finally to the House of Lords. What Mr. Rondel did is he appealed from various orders and used various other devices to get the matter established way up the sort of judicial tree. And obviously there had been quite a large number of previous authorities about the role and responsibilities of a barrister when conducting litigation in court. But on appeal, the application by Norbert Rondel was dismissed, because the view was at that time that a barrister was immune from an action for negligence at the suite of a client in respect of his conduct and management of a cause in court and the preliminary work connected therewith. And it then went on to say, the House of Lords, that immunity was not based on the absence of contract between barrister and client, but on public policy and long usage. In other words, as many of you may know, I'm a barrister at law. I don't have a contract with my client, except in very limited circumstances under public access. So therefore, the rules in those days were very straightforward. There are a number of points that came out of it, and a number of judgments by the law lords, which I think you may find of interest. Lord Upjohn, very well known to probably many of you, said, "As a practical matter, I do no more than suggest that the immunity of counsel in relation to litigation should start at the letter before action stage." He then went on to talk about costs involved in the case. In other words, he was looking to see when, in fact, this immunity from any form of suit, in terms of a cause of action, when it started. The other people who came up with some very interesting comments were Lord Reid, who of course was very well known for a mastery of issues involving administrative law, where he and other colleagues, Lord Morris and Lord Upjohn, said public policy does not require that a barrister shall be immune from action for negligence in relation to matters unconnected with cases in court. For if he fails to exercise the ordinary care and skill that can be reasonably be expected of him, he should be and is in no better position than any other professional man. Remember, this is 1967. The other point that came out, which Lord Reid and the others said, is that on the grounds of public interest, a solicitor, while acting as an advocate, has the same immunity from an action for negligence as a barrister does. Okay, so you've got the general drift of what happened in Rondel and Worsley. Let me conclude by saying that, of course, for many years this was the way in which the law operated. But slowly, with legislation coming through, the Courts and Legal Services Act and then the Access to Justice Act, it became obvious that there would have to be changes, because clearly, for people like myself, we have to have an insurance policy, a premium that I pay each year, to cover me for any aspects of work which I can be sued for, or could be even under the Rondel and Worsley precedent. That means the negligent preparation of cases and so forth. So what has happened is that since this decision, which was a landmark decision in 1967, we then had Hall versus Simmons in the year 2000, which scrapped our privileged position. Remember one thing, this is about public policy. That's the reason, none other. Thank you very much. Bye-bye.